Hello there. My name is Mutiawa Conrad. I am a lawyer, a private law tutor, and also a practicing advocate of the High Court. And in this video, we're basically going to be looking at the role, the powers, and the duties of the Director of Public Prosecutions. Of course, we are going to go a little bit more in detail, and we're going to be looking at the various functions that the DPP has. And then we'll also look at the powers that the DPP has. We'll be looking at the authorities that grant him or her the power and those functions which we're going to be stating. I'll also be sharing with you quite a number of cases which are very authoritative on the powers and the duties of the DPP. But just before we go into the details of our class, I encourage you to subscribe to my channel. Just press onto the subscription button just below there. Also turn on your notification and also like and share this video with your colleagues so that they are able to benefit from this video. Please comment or ask any questions down in the comment section and we'll be able to answer such questions. And then lastly, students interested in private law tutorial sessions, please contact us. Our numbers are down in the description box. These private law tutorial sessions have been proven to work, and students who are on these private law tutorial sessions have continuously been proven to outperform their colleagues who do not have any sort of mentorship. So let's jump right into our topic for today, and this is the role, the powers, and the duties of the Director of Public Prosecutions, who I'm also going to abbreviate as the DPP. So just before we go into those, just to give our class context, you have to note that for purposes of criminal prosecution, all these criminal prosecutions are done by a state prosecutor, or also call him or her a government lawyer or a government criminal lawyer. So that government criminal lawyer is known as the DPP, or the Director of Public Prosecution, who also acts through state attorneys at various levels or at lower levels. So now we are going to look at what is the role. Okay, for starters, what is the role of the DPP? Now, when you look at the Constitution, the role of the DPP is actually to prosecute criminal matters on behalf of the state. So remember, for criminal offenses, these are offenses predominantly that are executed or done against the state. So when crimes are committed, these crimes are done against the state. So the state prosecutes such offenses through the DPP or state attorneys. So that is the fundamental role that is played by the DPP. Now, having looked at the role that the DPP plays, let's now proceed to look at the constitutional provision on the office of the DPP. Now, the office of the DPP is established by the Constitution of the Republic of Uganda of 1995, and specifically I invite you to look at Article 120. That article is very authoritative. When you read under Clause 1, it actually establishes the office of the DPP. And if you proceed to look at Article 120, Clause 3, it actually goes on to provide for a number of functions of the DPP. So that takes us now to look at the functions of the DPP. As already stated, these functions can clearly be found under Article 120, Clause 3 of the 1995 Constitution of the Republic of Uganda. And his or her functions include the following. Number one, to direct the police on investigations, okay? And this is specifically criminal investigations, and report back to him. So what does this mean? This means that the DPP can actually direct police to investigate a certain matter. And after that investigation, he can also direct police to report back to him or her for purposes of advising and taking the decision to prosecute or otherwise. That's the first function. Let's now look at the second function. The second function is to institute criminal proceedings in any court, save for the court martial. So the DPP has powers to commence criminal proceedings in any court. The Constitution gives him or her those powers, except for the court martial. Let's now proceed to look at the third function. This is to take over and continue any criminal proceedings instituted by any person. So in case a private citizen institutes criminal proceedings, the Constitution gives the DPP powers to take over those criminal proceedings instituted by a private person. Let's now proceed to function number 4, and this is to discontinue at any stage before judgment is delivered any criminal proceedings, except, the only exception here is that, except that the DPP requires court's consent for proceedings commenced by another person. So let's throw some clarity here. If a private citizen commences proceedings by way of private prosecution, the DPP under the Constitution has the mandate and powers to discontinue at any stage, provided judgment has not yet been entered by court. He can discontinue those proceedings. But should the DPP choose to discontinue such proceedings, then he must get the consent of the court or the consent of the judge, less of which he cannot discontinue such proceedings. So those are the 4 functions of the DPP as provided for under the Constitution. Let's now proceed to look at the powers of the DPP. Now, these powers have been established especially under case law. One of the powers has been espoused in the decision of Uganda versus Wero Nsenga, which is criminal session case number 312 of 2013. And in that case, Justice Gaswaga observed that it's only the DPP and nobody else who enjoys the powers to decide what the charges in each file forwarded to him or her should be. Okay, so one of the powers is to decide what the charge in the police file should be. It's only the DPP that has those powers. Now, police can only advise and the DPP chooses, meaning that the investigating officer can only advise, but the DPP has the ultimate power to decide which charges are best in the circumstances. And these powers, of course, emanate or are acquired from Article 120 of the 1995 Constitution of the Republic of Uganda. So that's the first power that the DPP has. Let's now proceed to look at the second power. The second power that the DPP has is to prosecute offenses tried by the High Court. So he also has these powers. He can prosecute such offenses. Let's now proceed to the third power, and this is to prepare indictments and, of course, summaries as well. So that's another power that the DPP has. He has that power to prepare those indictments and summaries as well. Of course, summaries of the case as required under Section 168 of the Magistrate Courts Act. Please go and look at that section. Let's now proceed to the fourth power which he has. Now, this fourth power was espoused in the case of Henry Kayondo versus Uganda. It's a case of 1992 to 1993 High Court Bullet, page 41, where court held that the DPP is responsible for the correctness of the charge sheet. So the other power that he has is to correct the charge sheet. Okay, so he also or she as well has such powers. Let's now proceed to the next power, which is to enter a nolle prosequi in cases before the High Court as a means of withdrawing charges. So a nolle prosequi is simply a decision that can be taken by the DPP to withdraw charges. Okay, so a nolle prosequi is simply a document where the DPP can choose to withdraw charges that are or have been brought against any person. This, ladies and gentlemen, is provided for under Section 134 of the TIA and also Section 121 of the MCA. These sections and these authorities actually provide the DPP with powers to enter a nolle prosequi or to choose not to prosecute or withdraw charges against an accused person. Let's now proceed to look at another power of the DPP, and this is to consent to charges requiring his consent to prosecute. So it's important to know that under the law, there are certain charges that cannot be prosecuted unless the DPP clearly authorizes such a kind of prosecution to go on. For example, under the Anti-Corruption Act or under the Anti-Corruption offenses, these offenses, or some of them, require the DPP's consent before their institution. Please look at Section 49 of the Anti-Corruption Act. It's very clear. So these offenses pertaining to anti-corruption, the DPP must consent to such prosecution. So let's now proceed to look at another power, and this is to give his views in cases undergoing revision by the High Court before the revisional orders are made. This is a requirement of statute. I invite you to look at Section 50, subsection 2 of the Criminal Procedure Code Act. It provides for that power as well. So he has to give his views, okay, in cases undergoing revision by the High Court before such revisional orders are made. Let's now proceed to look at another power, and this power is provided for specifically under Section 132, subsection 1C of the Trial and Indictments Act, and basically this is to appeal against an acquittal if the same is erroneous in law. So in case an accused person has been acquitted and the DPP in his or her wisdom feels that such an acquittal is erroneous, then he has powers to appeal such an acquittal. And of course, the section which I shared with you, which is 132 subsection 1C, gives the DPP power to appeal as of right on matters of law, fact, or both. So meaning that the DPP can appeal as a matter of right on any fact of law or any matter of fact or law, or even both. So that's another power that the DPP has. Let's now proceed to look at another power which was provided for or espoused in the decision of Busiku versus Uganda, which is Supreme Court Criminal Appeal number 33 of 2011. This decision is unreported, but however, in that case, court observed, or rather the Supreme Court to be more particular, emphasized that the DPP's right of appeal under Section 132 subsection 1C of the TIA is paramount, and it is provided for by statute. Let's now look at another power of the DPP, and that is to represent the state in criminal appeals in all courts. So he has those powers. He can represent the government of the Republic of Uganda in all courts of law, whether it's an appeal or otherwise. And then finally, to appoint public prosecutors. So the DPP can, or rather he or she has powers to appoint public prosecutors to act on his or her behalf. And this is a creature of statute, specifically under Section 223 of the Magistrate Courts Act. So ladies and gentlemen, those are the powers of the DPP. And earlier in this video, we looked at the functions. We also looked at the authorities. And I've shared with you a number of cases that espouse all those principles. And we finally come to the end of our class. And once again, I encourage you to ensure that you subscribe to my channel. Just go down and ensure that you click on the subscription button. Also turn on the notification so that every time videos are released, this comes to your attention. And then also students interested in private law tutorial sessions, please feel free to contact us. Our numbers are down in the description box. And in case of any questions, please feel free to comment and ask questions down in the comment section. Just keep the questions coming and we'll be able to guide you whenever we have a minute. It was beautiful moving with you throughout the class. We'll meet again in another one. God bless you. Bye-bye.